appeal in the matter of Mercy Global Consult Ltd in liquidation into bracket and Adegbuyi-Jackson and others.
Yes, Mr. Venables.
My Lords, you have indicated that you would like to hear argument first on the question of the extent to which the decision of mainpaying the Court of Appeal binds this Court.
Yes. Wish to resist that suggestion?
I do not resist that suggestion. If I could just say how I propose to deal with this, I normally like to follow my skeleton argument through reasonably faithfully, so that you have the logic of it. What I would propose to do is not to comment at this point, perhaps not at all, on paragraphs 1 to 22 of my skeleton, which simply set the scene. However, if your Lordships would like me to hear very briefly through those first, I could do so.
No, I think I can confidently say, I know from our discussions, we have all read the papers carefully and we know the background, so I don't think any scene setting is necessary.
That's very helpful, Lord. So what I would propose to do now is to address your Lordships with some extended argument on the rules concerning binding precedent,
yes,
which are not in our skeleton. You'll appreciate that this was addressed in much greater detail in the respondent's skeleton, which was subsequent to ours. I've interpreted the question, I hope I've got this right, is the present Court of Appeal bound by the decision of the Court of Appeal in main pay to mean such that the value-added defence, if permitted to be pleaded, would be bound to fail before this court and any lower court?
that is exactly what was intended to mean.
My learned junior and I had a little confab and we thought that's what you meant, so at least we're all at one on that. Now, it's accepted that the decision in Kadim, which I shall be taking your Lordships to very shortly, that's at tab 12 of the bundle of authorities, is of course authoritative. It lays down a general rule as to when this court is bound by a previous decision of this court, but also deals with one relevant exception, namely that the Court of Appeal in the previous case simply assumed a point and did not consider whether it was correct.
Yes.
Your Lordships will note, of course, that there is already there a little bit of grey area in what's meant by an assumption and what's meant by a consideration. Now, I'm going to invite the court to hold, if necessary, and we may not get that far, that there is another exception. Namely, that a decision of the Court of Appeal is not binding, where it itself was based on a serious misconception. Or, in the words of a Court of Appeal authority I'm going to cite, there was a manifest error. And I'm further going to submit that that was the case with main pay. This would in effect be a new subdivision of the per incuria. And I shall be taking the court to an authority, Morel and Wakeling.
So what's the name of the authority?
Morel and Wakeling. It is quoted in Kadim at para 18. It's a decision of this court. Which, in my submission, gives some support for recognising such an exception in the case of, to use the words of the Court of Appeal in that case, manifest slip or error. Now, Morel is not in the bundle of authorities, but we have produced printouts, which
Have they been handed up?
Have they been handed up? They've been handed to the clerk, but perhaps not been handed up already. So
The answer is no.
they have not been handed up yet, and
Can we do that now?
they can be handed up now. I'll be going to Kadim first and then to Morel.
Well, there's no harm since this is the point to come up. Let's just get them. Sounds like they've only just gone to. Why have they only just now gone to your opponent to Mr. Baldry?
I think because it was at a late stage in our argument. You'll recall that.
Well, you've had time to print them out. You've had time for your junior to sit there nursing them. I'm bound to say I would have expected straight away when you knew you were going to be relying on them for you to send an email to the other side saying, here's this case, and we'll bring copies to court. And you've given them to them this morning.
I'm sorry that was not done.
Well, Mr. Baldry, I've made the point for you. I'm sure you'll cope. In the unlikely event you need time, you can have it.
I'm grateful.
Right, thank you. Well, we'll come to Morel in due course. Thank you.
Now, we have a principal argument and a subsidiary argument.
Yes.
The principal argument is very simple. Unlike everyone involved in Main Bay, we do not agree that the healthcare exemptions from VAT afforded by European law are the only ones in point.
One second.
We submit.
Hang on 1 second.
Yes. We submit that United Kingdom domestic law confers wider exemptions. And the proposed value-added tax defence does not depend on the exemptions afforded by European law, but on what we submit are the wider exemptions afforded by UK law.
It's a necessary part of such an argument to establish that it would be open to the UK at the relevant time to provide for a wider exemption than was permitted under the principal VAT directive. A matter which I don't think will be common ground.
My Lord, may I address that? It's something I perhaps would have addressed had I proceeded through the skeleton in the proposed way. The position is this. A directive does not per se automatically become part of the domestic law of a member state.
Indeed not.
If you'll bear with me. However, where sometimes, of course, directives do allow a certain amount of flexibility in how they're to be implemented. But let's assume there's no flexibility. Let's assume that the directive is absolutely categorical. If a member state fails to implement the directive in its domestic law, then a third party, such as a taxpayer, can rely on that failure before the domestic court.
The way I've come across this more in the context of employment law than of tax law, but presumably the principle is the same. We just put it more directly that where the claim is being brought against the member state, the directive will have direct effect.
Exactly, my lord. So far, I think that is totally unexceptionable. But it's the next stage which is the interesting bit. If the member state, let's say in this case, gives a wider exemption than is required or even allowed by EU law, it cannot say in proceedings, it cannot rely on its own breach of its obligation under EU law. So in this case, if, as we submit, the UK has in fact conferred wider exemptions from VAT than were required by the directive, and in a dispute between a state, or an emanation of it, in this case, HMRC, and a third party, a taxpayer, the taxpayer says, I'm taking advantage of the exemption under UK law. What the UK cannot say is, oh, actually, we didn't need to give you those exemptions, or perhaps even we shouldn't have given you those exemptions. The UK cannot take advantage of its own wrong. And I'm sorry,
Well, an answer to that might be that the apparently wider exemption in the domestic legislation must be read down in accordance with slightly unusual application, but the principle will be the same, in accordance with leasing, so that in fact the apparently wider exception is treated as a matter of domestic law as ineffective, that's one way of putting it, is construed as not extending beyond what is permitted by EU law. That would be a more orthodox way of putting it. We'll get round your point about relying on their own wrong.
well, your Lordship says a more orthodox way. This, of course, is, if the VAT defence is permitted, this is a point which will be entirely open to mercy to make. That the UK law should be, I think there's sometimes called the principle of sympathetic interpretation, should be interpreted, if at all possible, in such a way that it is not inconsistent with EU law.
So you're saying that point would be open to mercies, and wouldn't it be open to mercy and right?
Well, it wouldn't be right. Well, to discover whether it was right in this particular case, one would have to look at what the European law actually said. One would have to look at the terms of the UK statute, the Value Added Tax Act, and one would have to consider whether it was capable, whether the Value Added Tax Act was capable of such interpretation.
So what you're really saying is it wouldn't be capable of summary determination. You're
Oh,
really saying it wouldn't be appropriate for summary determination.
Indeed, my lord, and before Mr. Justice Richards, I did in fact go into this to some extent. I didn't quote Leasing itself, but I quoted Vodafone 2, which is a very good collection, summary of the principles. And I said, I don't think he mentioned it in his judgment because, of course, having decided that he wasn't going to allow the amendment, the VAT defence to be put forward, he didn't really get that far. But in essence, I'd say in this case, the wording is so different that even on Marley Singh, Vodafone 2, or rather applying them, you simply can't get to a position whereby sympathetic interpretation, UK law is the same as EU law and no wider. That, of course, I say, is clearly a matter on which Mercy could disagree and could make submissions.
Yes, sorry.
And
was my lord about to make a point?
But I was going to ask a question, which is,
Sorry.
well, first of all, I observe that we don't seem to have any argument in the skeleton arguments about the relevant principles of EU law. But leaving that aside, at the moment I'm failing to understand the relevance of this argument, because on its face, main pay is a decision about the interpretation of the relevant items, particularly item 1, in the domestic legislation. So even if you're right that the domestic legislation goes further than is permitted by EU law, so what?
well, because the whole argument and the whole reasoning in Vodafone, I beg your pardon, in main pay, was based on EU law. It was simply assumed that if there was no exemption available under EU law, then it followed that there was no exemption available under UK law. No separate consideration, to use the wording. No consideration was given to the point whether UK law might be wider than EU law.
They were still deciding the question of UK law.
It is, but when it comes to, rather leaping ahead a little, when it comes to whether the Court of Appeal in main pay considered whether the UK exemption might be wider than the EU exemption, the answer is it didn't. So the VAT defence is based entirely on that, a point which was not considered, but if you like, simply assumed in main pay. And briefly, Dean says...
You've got to identify what was the question asked, haven't you? What was the issue that was decided?
Well, yes, you certainly have to do that.
And what were or were not, what authorities were considered or what arguments were considered might be a different matter. But the first question is what was the point decided?
Well, exactly. What was the point decided and what was assumed? It's, as we come to Kadim, we'll see there is a distinction between a point that was necessarily decided. Of course, it was decided in main pay that the UK exemptions were not in point. But whether that would only form a binding ratio if that was a point which was, to use the language of Kadim, considered by the Court of Appeal. And if nobody had argued that the UK exemptions were wider, and if the court had not even addressed its mind to the fact that they might be wider, then it had not been considered, and hence it is not binding authority. That's the relevance in this context. Your Lordship looks doubtful. Perhaps it may become clearer as we go through.
Yes, please make it clearer.
I will try if I may. It's always difficult, as your Lordships will know, in an argument, chicken and egg, which do you put first? Do you read the case first, without having concentrated on the relevance, or do you deal with the relevance? I'm dealing with the relevance first, and then I shall go through the case.
It's been helpful. I'm afraid any advocate who starts by setting out their stall, so to speak, which you've helpfully done, has to take the risk that the court starts questioning it straight away. But
Inevitably.
that's been a useful exchange. And if you want now to come to Kadim or finish setting out your stall, that's fine.
Thank you, my lord.
Well, you mentioned there was a subsidiary argument to come, so it might be helpful to give us a heads up on the subsidiary argument.
I will. Could I just complete? It's only a couple of sentences more, I think. It's really stating the obvious that if the members of the court in main pay thought about the matter at all, which is perhaps rather unlikely, that is, whether the UK exemptions were perhaps wider than the EU exemptions, they simply assumed that they were coextensive with the EU ones, and therefore did not consider, within the meaning of Kadim, the point at all. Hence, I would submit that on this principal argument, we fall fairly and squarely with the exception in point in Kadim, that this was a mere assumption, not considered by the court. I'll obviously have to take your lordships to Kadim, and I'll have to take your lordships to main pay in the Court of Appeal to expand on this. This is a kind of overview of where I'm going. If it's not helpful, then there'll be fuller argument later. Now, your lordship.
Yes, but could I just put down two markers for you to deal with later, not now? Firstly, in what respect you say the UK exemption goes wider than the EU exemption and how that's possible? And secondly, in the sense of just looking at the interpretation of the UK legislation. Secondly, why you say, even if that would be the interpretation of the UK legislation absent anything else, you say that's permissible as a matter of European law. Because I have to say my understanding is that it's not permissible.
Well, there's two weighty points. I'm grateful that your lordship has given me an indication that he would like them addressed, and I will address them. It won't be this morning. I suspect I will have to perhaps go back and look at some authorities on this. But I'm grateful to your lordship for that indication of matters which are concerning your lordship.
Well, if I may respectfully make an observation, since these 2 points are inherent in your argument, I'm a little surprised to hear that you're not ready to argue them. But there we go. Please take your own course.
Well, I'm sorry I have misunderstood your lordship's observations. I thought you were expecting me to deal with these in future. I can.
All I'm saying is I think we need to be addressed on these points at some juncture.
At some stage. And at some stage. I could address them now.
But I think my lord prefaced his observations by saying these were 2 markers for later.
Yes.
So I don't think you are being invited to deal with them now. I think it was being warned that these are points we will want to hear submissions on.
I'm not saying that I'm not prepared to deal with them.
Fine.
In a general sense.
Fine.
That these are entirely new matters. It's just that when one
Well, don't worry about that. It was an observation by my lord, which I understand, but doesn't require a response, I don't think.
well, it does require a response, but later.
Yes, quite.
Now,
Can I just ask though, am I right in thinking that the amended defence does not contain a pleading that, and it may be the structure of it didn't require, but let's be clear about this, it does not contain a pleading that domestic law, well, in support of the allegation that effectively VAT was not due, that there is a difference between domestic and UK law.
Well, look,
It's not necessarily a criticism, because you don't need to plead points of law, and it really goes to an answer, which is you're bound by main pay. But I just want, nevertheless, to be clear that you couldn't look at the pleading and find this averment.
I wonder if we're at cross purposes more, because the amended defence doesn't, of course, include the VAT defence. That's the whole point. We've not the.
But I thought, oh well, perhaps I'm at cross purposes. One thing I haven't particularly focused on is the pleading, because I didn't think it was necessary to do so on the way the argument was put. But I would assume, was there not a draft pleading before Mr. Justice Richards?
Oh, a draft pleading.
Yes, that's what I'm talking about.
Isn't that what we've got at 8A?
8A, yeah.
I think that was the draft amended pleading for which you were seeking permission, but which he refused.
Yes, I'm sorry. When I said amended defence, it's called draft amended defence. I'm sorry if I didn't use the word draft.
Now, I should explain that in this matter, although I'm the leading counsel, my role is limited to advising on VAT, and it's really my learned junior, Miss Levy, who has the general conduct of the litigation. May I perhaps...
Fair enough, but the amended pleading is signed, the draft amended pleading is signed by you and her.
Indeed. I wonder if it might be more helpful if your lordships heard response from Miss Levy on this point.
All right, well, it's a marginal point. I just really wanted to be, and I don't think it need disturb us now. Perhaps at a later stage, you can just confirm or otherwise that there is no paragraph in the amended pleading, draft amended pleading, for which you were seeking permission, which makes the points of law which you are now making.
That's right, and my learned junior has confirmed there's no such pleading.
No, that doesn't surprise me.
And as your lordship says, of course, we might have been criticised had we pleaded points of law.
No, fine. It's just part of the background. Thank you.
So I was going to deal with the subsidiary argument. The subsidiary argument is much more involved than the principal argument. It involves a consideration of what was the ratio of main pay, and whether in reaching that ratio there was manifest error in the reasoning of the court. In particular, just to flag this, the major point of criticism is that Lady Justice Whipple stated categorically there was a distinction between a supply of staff and a supply of services, and a supply of staff could not be exempt.
Yes, so that That's the manifest error point that you flagged up at the very beginning. Isn't it a little bit it's slightly pointing us in the wrong direction to talk about considering what was the ratio of main pay? The whole problem about identifying the ratio would be relevant if you were arguing we weren't bound. We weren't bound on conventional principles. Really, your point here is that she got it so badly wrong that on your new principle, which you're going to support by reference to Morel, we're not bound by it. So, in one sense, I appreciate it's an attack on the ratio, but you're basically just saying she was so badly wrong that we're not bound.
That's the real point,
Yes.
my Lord, yes.
And perhaps this is a good point just to pick out a point which I think Mr. Baldry made. Mr. Baldry said that the right approach to this is first of all to identify the ratio and see whether that is subject to Kadim binding. And then secondly, if it is binding subject to Kadim, to ask whether it was based on an assumption, which is the Kadim exception. I don't think either of the points you flagged up involve a challenge to point one, i.e. I think you're accepting that it was part of Lady Justice Whipple's ratio that there was a distinction between the supply of staff and the supply of services, and the former could not be exempt. But you're challenging that on two bases. One, that was based on an assumption, and secondly, the new point, based on Morel. Have I got that right?
Absolutely, my Lord.
Yes. Well, that's helpful. Right, well, that's you setting out your stall, and that's been a helpful first run round the course. You're now going to go into the points in more detail, is that right?
Yes, first of all, I'd like to take your lordships to Kadim,
Yes.
and then to Morel. Kadim is in the authorities bundle, tab 12 at page 123.
Yes.
Page 123, and picking up starting at the head note between D and E. The judge held himself bound by a previous decision of the Court of Appeal to hold that the regulation in question provided a complete test of residence, and that sharing of accommodation other than a bathroom, lavatory or communal area necessarily meant that the persons concerned were residing with each other, and accordingly refused the declaration. On appeal, held first that the court was not bound by proposition of law, which, although part of the ratio dicadendi of an early decision, had been assumed to be correct by the earlier court, and had not been the subject of argument before or consideration by that court. That exception to or modification of the strict rule of precedent was to be applied only in the most obvious cases and limited with great care, and would not normally apply unless the point had not been expressly raised before the court. That there could be cases where a point had not been the subject of argument, but scrutiny of the judgment indicated that the court had nevertheless considered the point, rather than assuming it to be correct. I ask your lordships to turn to page 129, which is paragraph 16 of the decision. Cases as such do not bind. Their ratio is decidendi do. While there has been much academic discussion of the proper way of determining the ratio of the case, we find the clearest and most persuasive guidance, at least in a case such as the present, where one is dealing with a single judgment, to be that of Professor Cross in his book. The ratio decidendi of a case is any rule of law expressly or impliedly treated by the judge as a necessary step in reaching his conclusion, having regard to the line of reasoning adopted by him. We then go to paragraph 18, which is headed per incuriam question mark. The only escape from the ratio of a previous decision of the Court of Appeal has for long been thought to be provided by three categories of case set out in the judgment in Young and Bristol Aeroplane. My lords, I reread that case, but I don't think there's anything in it that we don't get equally well from Cadine. Of course, the only one even potentially applicable to the present case is that the court is not bound by a previous decision reached per incuriam. That rule is, however, to be understood in narrow terms. As Sir Raymond Evershed, the Master of the Rolls, put it in Morel and Wakeling, as a general rule, and I'd like to stress at this point general, the only cases in which decisions should be held to have been given per incuriam are those decisions given in ignorance or forgetfulness of some inconsistent statutory provision, or of some authority binding on the court concerned, so that in such cases, some part of the decision or some step in the reasoning on which it is based is found, on that account, to be demonstrably wrong. Well, Lords, when I take you to Morel, I'm going to take you to this quotation, but to further parts of it. Then, to paragraph 20, assumption without argument. Mr. Cox relied instead on a slender line of authority for a proposition.
So far you've just taken us to short passages, and that's fine if you read them out. Just as a general point, if you're going to take us to longer passages, which I suspect may be the case from now on, it's easier to us just to read them, but up to you.
I could ask you, my lords, to read paragraphs 20 to 25, but could I stress that I would like to underline the final words of 23, that it may often be one that is not specifically thought about.
Thank you. Well, let's just remind ourselves of those, and we'll tell you when we're done. Yes, thank you.
Could I just comment on paragraph 25? It's mentioned that in Goonery, the previous Court of Appeal case, the disputed proposition was specifically stated by the court. In this case, as far as the main argument is concerned, it was never specifically stated by the Court of Appeal in Main Pay that the UK exemptions were no wider than the EU exemptions. In other words, this is to that extent a stronger case than Cadine. If your lords would now perhaps read paragraph 29, which is quite a long one.
Thank
on Rakel.
Yes.
And may I just stress the quotation from Lord Justice Russell at the top of page 132 of the bundle. That question was not in issue in that appeal. In this context, as far as regards our main argument, it was not an issue that the UK VAT exemptions were wider than the EU ones. And as regards the subsidiary argument, which is based on the said supposed distinction between a supply of staff and a supply of services, that was accepted by the taxpayer up to and including the Court of Appeal.
Is that right? I thought it was particularly challenged in the Court of Appeal. See para 82 of Lady Justice Whittle's judgment.
Well, para 82, your Lordship's right, para 82 is a difficult paragraph to understand. But looking ahead, paragraph 82 is...
Well, perhaps
I could just explain
if you want to flag, either deal with it shortly now, or by all means put it off for the future. I'm just putting down a marker that I don't accept for the moment that it's right that the distinction between the supply of staff and supply of services was common ground in the Court of Appeal, which I think is what you were saying.
Well, I think I can deal with this very shortly now,
Okay.
though I'll come back to paragraph 82 of the decision later. It was admitted, subject to this point, that there was such a distinction. And whether one supplied staff or whether one supplied services depended on the degree of control. Which, incidentally, there is no mention in either the EU legislation or the UK legislation of any concept of control. Now, when the series of paragraphs starts at, I think, in main pay in the Court of Appeal, starts at, I think, paragraph 79, when what Lady Justice Whittle says is that Mr. Firth, I think, for the appellant, main pay, introduced three variant arguments on control. And she says first, second, and third. Paragraph 82 is the second of those. And so...
I thought it was the third. But
what was the third?
I thought the one what the point I'd be putting to you was the third, not the second.
Maybe it was the third one, my lord. Forgive me, but it was certainly one of the three variants on control. And so the passage is a little ambiguous as to what exactly he was arguing. Again, I'll come back to this later. But it looks as if this was very much, as she said, a variant on, or part and parcel, of the control test, which in turn was part and parcel of a supply of staff cannot be a supply of services proposition.
Okay.
I'm sorry it's so involved, but I can't make the case.
No, we're
Simpler
all
than
very
it is.
familiar with it. But thank you. So, should we go back to Kadim?
Yes. Now, while the court says the exception will be relatively rare, it cites authorities in support, which shows that it's not that rare. If I could invite your lordships to read para 31 and para 32. Decisions of Mr. Justice Warner and of Sir Nicholas Brown Wilkinson, as he then was when he was Vice Chancellor.
Yes, okay. Give us a moment. You say and 32? Yes, and 32 itself
31
cross refers to other cases which Sir Nicholas has looked at. Yep, okay.
31 and 32.
Yes.
May I just stress certain passages in that right at the beginning? Mr. Justice Warner determined that there was a general principle that where a court assumes a proposition of law to be correct without addressing its mind to it, the decision of that court is not binding for that proposition. And then the quotation from Sir Nicholas Brown Wilkinson. The authority has therefore clearly established that even where a decision of a point of law in a particular sense was essential to an early decision of a superior court, but that superior court merely assumed the correctness of the law in a particular issue, a judge in the later case is not bound to hold that law as decided in that sense. And, of course, right at the end of 32, you have the comment of the Court of Appeal that they regard that conclusion as strongly persuasive in the present case.
Yes.
If I could ask your lordships now to read paragraphs 33 to 38.
Yes. Yes, thank you.
And my only comment I need to make on that is I think the beginning of paragraph 38, like all exceptions to and modifications of strict rule of precedent, this rule must only be applied in the most obvious cases and limited with great care. Of course, it's our submission that this is one of those cases.
Thank you.
If I can now take your lordships to Morel and Wakeling, which was handed up this morning. You'll recall that there's a quotation from this, a short quotation, in Kadim at paragraph 18.
Yes.
What I would like to do is to read the extended version of that. Is at page 406 on Morel and Wakeling. And I should mention that this is the judgment of Lord Evesham, who was Master of the Rolls, but it was the judgment of the court.
Court of 5.
I think it was 406, was it 405?
A court of 5.
I'm
Usually, if you look at page 379, it was Lord Evesham, well, Sir Raymond, is he? I think.
Sir Raymond, I'm sorry.
Whichever he, well, I'm not sure which he was at that point.
He was Master of the Rolls, I think.
Let's call him Lord Master of the Rolls.
Yeah.
Then Lord Justices Dennis, Jenkins, Morrison, Rona. Yep.
So page 406, it's the first break.
Just give us a moment to, we'll just skim read the head note to see what the issue was.
Indeed, I better warn your lordships, this is a matter of some enormous complexity.
Well, fortunately, I doubt, as far as we're concerned with principle, unless you try and persuade us otherwise, I doubt if we'll need to grapple with the complexity, but we'll get the flavour of it, at least from head note. So give me a moment. I see it was one of those valuable cases in which Magna Carta was cited.
Mm-hmm. And there were some future Lord Chancellor here.
Yes, you could say certainly distinguished counsel on all sides. Right, let's just read through it.
So then picking...
Sorry, we haven't had a chance to do that yet.
I'm sorry, my lord?
We haven't had a chance to read through the head note yet.
I'm sorry.
Yes, it's really only the first point in the head note that matters for our purposes.
Yes, my
Yes, thank you.
So,
So
then if
now
if
you
I,
want to take us to the judgment itself.
yes, it's page 406 at the first break.
Again, is it a long passage, that, in which case do you want us to read it all? Tell us how much you want us to read, unless it's a short passage.
It's so starting towards the end of the first line, as a general rule,
Yes.
and going down to the end of the quotation marks about 2/3 of the way down the page.
Yes, speaking for myself, I think I'll read to the end of the paragraph. Yes. Okay, thank you very much.
And the only part I'd highlight about halfway down page 406, it's a sentence which introduces the quotation. As we've already said, it is in our judgment impossible to fasten upon any part of the decision under consideration, or upon any step in the reasoning on which the judgments were based, and to say of it, here was a manifest slip or error. And we lie that for the proposition that, conversely, where you can say of steps in the reasoning, or indeed any other part of the decision under consideration, here was a manifest error, then the authority is not binding precedent. My Lord, I now propose to return to my skeleton our skeleton.
But perhaps, if you're, so that, I take it that you are not intending, therefore, to refer us to any later authority that picks up that particular passage, the one you just emphasised from Morel, and says that this is the real test in a per incuriam case.
No, my Lord, because I know of none.
No. Nor any textbook authority which says that this is the underlying principle.
Well, to say it's an underlying principle, I would submit it is a, no, there is, Morel is Morel, and in my submission it allows, if you like, a further subhead of the per incuriam.
Yes, no, I see exactly how you put it, and I see the basis
That-
on which you put it.
that
I just
is
want to
the
know
only
whether anyone else has gone down that route. Neither an academic nor another case.
Not so far as I'm aware, my Lord.
Thank you. Yes, thank you. You said I think now you're going to take us back to the Stellarton argument.
That's right, which is starting at paragraph 24. I think 24 and 25 I've already covered. If your Lordship should just briefly read them again.
Can I just ask, in view of what we've read from Morel, am I right that your references in paragraph 19 of your skeleton, the fact that main pay was represented only by junior counsel, who does not appear to have been instructed by solicitors, that's completely irrelevant?
According to Morel, it is, my lord, yes.
Well, do you suggest otherwise?
Hmm?
Do you suggest otherwise now?
Well,
Just wondering why it's there.
maybe to explain, well, it is not relevant as a matter of law. And present, I agree. But if one asks, if your Lordship was saying to yourself, if this VAT point is really such a good point, if this is VAT defence, why wasn't it raised in main pay? And the short answer might be you have relatively, wishing no.
I think this is a very dangerous and rather unattractive course to go down. As it happens, the court has had experience of counsel to whom you have referred, who was instructed in main pay, who is, I think, 10 years call in specialist tax chambers. The fact he's not instructed by counsel is very common, by solicitors is very common in tax cases in particular. It's, frankly, a thoroughly bad point, isn't it? Shouldn't have been taken.
I'm grateful for that, my lord.
Yes, sorry, you were on. I think you wanted to pick up a little further along. Which were the paragraphs you were taking us to?
I was going back to my skeleton at 24, 25, but I think also 26 we've covered.
Yes, well, there again a question arises because the first sentence in paragraph 26 states the taxpayer relied at all stages exclusively on European Union law. Well, at the moment, that seems to me to be inaccurate because, as one sees very clearly from the Court of Appeal's decision, reliance was placed upon item 1 in particular of Group 7 of Schedule 9, and one also sees that at lower stages in the case, reliance had also been placed on item 4. So it does not appear to be correct to say that the taxpayer relied exclusively on EU law.
Your Lordship is correct. Well, of course, these were proceedings in the UK. This was a UK VAT appeal. And of course, the primary legislation to be argued about was the UK Value Added Tax Act. Perhaps I can refine this and say that the taxpayer, the whole of the taxpayer's argument was based on the exemptions afforded by EU law.
Well, they're also afforded by domestic law.
Oh, yes, yes, indeed.
So I mean, everything in the VAT regs comes from EU law.
Ah,
They're made under section, well, I'm assuming, made under section 2 of the European Communities Act, aren't they?
Well, it's primary legislation. It's the
Of course it is, yes.
It's the
forgive
VAT
me.
Act 1994.
Yes, I'm so
but
sorry.
Nevertheless, it was an implementing act.
Yes. I think you said VAT regs, or perhaps I missed.
Oh, did I, Lord?
No, or maybe I misheard or misunderstood. My Lord's obviously right, so forget that point, but still the underlying point is the same.
Well, the point is that the sole argument was based on the scope of the exemptions under the Principal VAT Directive, part of EU law. There was no independent, and of course, it was accepted that this had been transposed into UK law. And I would accept that. That is that, indeed, the exemptions which should have been made available under the directive have been made available in the Value-Added Tax Act. But the question we propose to raise in the VAT defence is whether, in addition to that, the Value-Added Tax Act has conferred wider exemptions. That was not considered at all.
All right, but that is your main point, which you're going to be developing. But my Lord is simply putting to you that it's, with respect, not accurate to say the taxpayer relied all stages exclusively on EU law. On the contrary, the taxpayer was relying on domestic law, and it's a truism to say that domestic law in this field derives from EU law. You're making a different, a much narrower point, that it was the domestic law on which it relied was wider than EU law.
Yeah, I've obviously not made the point clearly enough in paragraph 26. What it should have said is that the only arguments adduced on behalf of the taxpayer were ones as to the scope of EU law, and there was no argument.
Forgive me, isn't that putting it the wrong way round? The question was what was the scope of the value of the exemptions in the domestic statutes, and your point is that the only arguments that were looked at were in relation to the scope of EU exemptions. It wasn't suggested that domestic exemptions were any wider. That's just a matter of what arguments were advanced in construing or interpreting the scope of the UK exemption. What you're saying is that there was another argument open to main pay, which was the UK exemption should be construed more widely than European exemption.
That is right, my Lord, but it goes further in that when one asks what did the courts, what did the tribunals, and in particular what did the Court of Appeal decide, their decision was based purely on arguments as to the scope of EU law.
I don't know what they're based on, but what they decided was the scope of the UK exemption.
Indeed, I suppose this takes us then to the distinction, which I think is not its common ground, which is made in Kadim, that, of course, the ratio of main pay in the Court of Appeal is that the exemptions afforded by the UK Value-Added Tax Act were not available.
Well, isn't it a classic case where what you're saying is that the court had not, on the earlier occasion, had the benefit of the best argument that researchers in industry or counsel could provide? You're saying there was another argument which could have been run, and it wasn't.
It goes, with respect, I can see that if that were the only argument, I'd be in very great difficulties. For a start, we just looked at Morel, where that is expressly rejected.
That's what I was reading from. That's what I was reading from. Yes.
Indeed. But there is a separate point, which is the point, Lord, which is the point that's made towards the end of Kadim. I suppose the Reid case and Lord Justice Russell in this court, saying you've got to ask not simply, you have to distinguish between a point which was put, but not argued particularly well, perhaps, which might have been argued better, or there might have been other arguments in support of that point, and a point which wasn't in issue at all.
And the point that was in issue was the interpretation of the UK exemption.
Yes, but
You're saying that there was an argument which was available, but which wasn't deployed, was that exemption might be wider than the European exemption. That's what it comes down to.
Well, I would describe this is made. It's not just semantics. I would say that was a separate issue.
Well, it is. Well, I mean, this seems to me to be the crucial point. There are issues in an appeal case, but let's say an appeal, in support of which a number of different arguments can be advanced. You could, I suppose, label each of those supporting arguments a separate issue. But that way, madness lies, because it can't be the case that every supporting argument in a complex case requires to be, every supporting argument that could have been run is to be categorized as an issue, and if it wasn't run, you can say that the issue wasn't argued. There has to be a distinction at some point between an issue and a supporting argument. Would you accept that?
Absolutely, my lord.
So what is the touchstone for distinguishing between the two?
Well, that there, with all these cases, it may be a question of fact and degree. It may be that there is no single litmus test that will unfailingly provide the answer. But I would say that if in a case like this, you have an agreement, concession if you like, well, an agreement that the Value Added Tax Act gives effect to the EU law. And the let me use the term issue, let me use a neutral term. The only point between the parties is the scope of EU law. Then the issue in the case was effectively, what was the scope of the EU exemptions? There's a very clear-cut distinction between that, I would say, is one issue, and a quite separate issue, not approached at all in main pay. Does the UK Value Added Tax Act afford exemptions which are not available under UK law?
Well, another way of putting it might be, I might say a more natural way of putting it, the issue, since this was a case being fought, as you say, in the UK, was what was the scope of the exemptions in the domestic legislation. That was the issue that was decided. An argument that the domestic legislation went wider than the EU legislation wouldn't be a distinct issue if raised, would it?
Well, the difficulty is this, my lord, that your lordship is quite right that not every argument can be a separate issue. But there can be separate issues involved in determining the question.
Aren't you doing exactly what is warned against in Morel when it says that you can't argue that you didn't have the best argument in the previous case? It says such a proposition would, it seems to us, open the way to numerous and costly attempts to reopen questions now held to be authoritatively decided. That's where it refers to the request to sit in a court of five, and it says that in effect that is usurping the function of the House of Lords to reverse a previous decision. And what you're saying effectively is that decision was wrong because there is an argument which what goes the other way?
I see how your lordship sees the point. You'll forgive me if I spend some time on this, because obviously it's crucial for our case. But in many a tax appeal, for example, the question will simply be, is the assessment made justifiable in law? And you might say that's the only issue. Because at the end of the day, all that the tribunal or a court on appeal is going to have to decide is yes or no. Perhaps in some cases in part only, but in most cases yes or no. That would mean that there could ever only be one issue in an appeal, because there was only one question to be decided. Now, I admit that that's going too far, that you can have, or for example, you could have alternative grounds on which the revenue might seek to uphold an assessment. And if it succeeds on any one of those grounds, then the appeal against that assessment fails. Now, in a case like that, surely it would not be an abuse of language to say that there were several issues. They were quite distinct questions of law. Even though, in a sense, the only question the court has to decide at the end is whether the appeal is to be upheld, is whether the assessment is to be quashed. Now, in my submission, the difference between the two questions, is an exemption available under EU law, and is an exemption available under UK domestic law, irrespective of EU law, are such distinct questions.
Why? Because the issue is the same, namely, what is the scope of the exemption? The whole point in main pay was, could main pay get themselves within the exemption or not? And that depended upon the scope of the exemption. Once the scope of the exemption had been determined by the court, the answer to the appeal was no, they couldn't get themselves within it. So the fundamental issue the court was deciding, surely, was the scope of the exemption. True it was that, as you say, an argument about differing scopes, allegedly, of UK and EU exemptions was not presented. But that argument would have gone to the same issue, namely the scope of the UK exemption.
I know of no authority because as to what is an issue and what isn't, and of course it could have different meanings in different contexts. I wonder if I could just step back a moment and see whether this difficult question, in fact, needs to be resolved. Because, yes, it does, doesn't it? Because the view that's being put to me is, provided something was in issue, it's irrelevant that it could have been supported by alternative arguments and alternative cases altogether. That, all I can say is, it would be extraordinary, would it not, if the decision of, say, this court were held to create binding precedent, where a whole area of the argument, not simply arguments, a whole proposition, namely that there were independent, wider exemptions conferred by UK law, had not even been argued or addressed.
But forgive me, that seems to me that misstates it. You say that there are wider exemptions under UK law. The problem with that is that the court was interpreting the UK exemptions. So it's not a matter of the court didn't consider whether there are other UK exemptions which are wider. The point is, it wasn't argued that those exemptions might be wider than the EU exemptions. But that doesn't mean the court wasn't interpreting the width of the UK exemptions.
I am, of course, with you that that's what the court was deciding.
But you're expressing it, forgive me, in a way which seeks to give your argument legitimacy, but you're expressing it incorrectly. The court didn't fail to consider further wider exemptions. It was considering those very exemptions. It just did not have before it an argument that they were wider than the EU exemptions.
Let me take an imaginary, not totally fictitious, but an imaginary example from tax law. The case before a court is whether, if the trustees of a discretionary trust make a discretionary payment of income, that becomes taxable income of the beneficiary. This is based on the House of Lords authority in 1915, but I, of course, needn't take your lordships to it. And the court holds, yes, it is taxable income of the beneficiary. However, in a later case, a taxpayer comes along and says, well, yes, I did receive a discretionary payment from the benefits, from the trustees of a trust, of a discretionary trust, but it's not taxable income because it was scholarship income. This is another case that went through the... And there is an express exemption from tax for scholarship income, which nobody in the first case mentioned.
Well, it would have been available on the facts you're...
Oh, yes, sorry, of course, on the hypothesis it would have been available. Now, in a case like that, wouldn't it be extraordinary if the taxpayer in the second case had to try to go, if it was indeed possible, had to go all the way to the Supreme Court to get
Well, I think it would, but it's not the same case. It's a rather clear case of per incuriam that a particular statutory provision was not relied on. I forget the exact phrase, but that's a classic per incuriam case.
Your lordship's right, and that's the disadvantage of inventing examples off the hoof. I withdraw that example. You're right, there is another solution to that.
But I take your point, and the point in which I welcome help from you and in due course from Mr. Baldry, that it may not be all that easy at a general level to adopt a single touchstone for what is an issue and what is a supporting argument. It may be, however, that this isn't a case that really comes up against that difficulty for the reasons put by my lord in his question to you just now. But anyway, if we have to accept there isn't a single touchstone, it is a question really then of policy, judicial policy, how central the point would have been if taken And the underlying policy is very clearly stated in Morel that it is contrary to the interests of finality for this court to be willing to go behind what would otherwise be binding precedent, simply because it said, oh, well, an important other argument wasn't raised. And although this wasn't the particular point they had in mind in Kadim, it's essentially the same point that's made there, where they talk about the need for extreme caution. You've got to remember, there is always the Supreme Court to sort out errors, and they're not bound by previous decisions, even if they're their own. We've got to be very, very cautious about this sort of argument, haven't we? Because it's always easy to say, as you say, oh, well, this isn't really just a supporting argument, it's a whole different issue.
I can see the force of what your lordship says. Of course, in realistic terms, not everyone, and hardly anyone, is going to be able to take their case to the Supreme Court.
Maybe not, but I mean, that's a dangerous argument. Certainly everyone in principle can.
In principle, yes.
Not only
And
that,
that's how,
in some cases, you can have the short circuit of a leapfrog appeal. I noticed that wasn't tried in this case, but I mean, at least in theory, one course that might have been open to your clients, I say might not, would be to accept that main pay precluded the argument and that needed to be overruled, seek a certificate from the High Court under Section 12, and then go direct to the Supreme Court saying, please take a leapfrog appeal because we want main pay to be overruled.
Yes, indeed, my lord. We had hoped we would not have to get, well...
Indeed, so that's why you're here.
That's why
precisely because you're trying to avoid that. Understand that. But I think where all this discussion takes me, at any rate, is that I'm sympathetic to your argument that there's no single touchstone, and therefore inevitably you have to look at the specifics of the particular case and this particular argument. And therefore, for that reason, I'm interested in the specifics of the present argument. And as I indicated earlier, one of the things that I'm puzzled about is what the starting point for your present argument is. Because I'm really struggling with how and in what respect you say that Item 1 of Group 7 of Schedule 9 to the 1994 Act is wider than Article 1321C of the Principal VAT Directive. Because at the moment, I'm really struggling to see any daylight between the two.
Then perhaps it would be, again, had I followed my original plan of going through the scaffold, we'd have introduced these at an earlier stage. This is one of the inevitable difficulties of trying to go straight to one point. Could I take your lordship's...
Your experience, you will have no difficulty in dealing with the point now, even if it's not when you originally intended to deal with it.
Oh, no, and perhaps it's a really good idea that I do at this point, because if it's troubling Lord Justice Arnold, then the sooner we see this, the better. Perhaps it's best to start with the European law. That's at Divide 5 of the Authorities Bundle, page 23.
Yep.
So we need to pick this up at page 24. Right-hand column. It's Article 132. And this sets out the exemptions. The two which are in point are Article 1321, B and C.
Well, do we need to worry about B? Because in main pay, B was not relied on. was only C that was relied upon.
Which bear with me a moment, I'm trying to get to the... If your lordships have the actual bundles, it's Schedule 9 will be at tab 2. Schedule 9, the Value Added Tax Act, which contains the UK exemptions. It's at tab 2 of the authorities bundle.
Yep.
We rely, of course, we do rely on both B and C. Sorry, as it were, we rely on items 1 and items 4. But concentrating on Article 132C, the provision of medical care.
Can you just help me on one thing? I haven't had to come across these provisions before this case. Is it recognised that there is an overlap between 1 and 4? That is to say, something can come both under 1 and under 4.
I don't know whether recognised. I would certainly accept there must be some degree of overlap.
Yes.
I don't know whether Morel and Friends has any views on that.
And 1 is framed in terms of the supply of services by medical professionals, in short. And so that's the key test, who's supplying the services. 4 is concerned with the provision of care in a hospital. So that the key question is, where is the care or treatment being provided? Sorry if I'm spelling out the obvious, but I'm just trying to work out how the two fit together.
Well, there is certainly a degree of overlap. I should just say as a marker that if the VAT defence were to be allowed, there would be an argument as to whether 4 does require the provision of care to be in any hospital. That's not relevant to the point your lordship's making.
Why?
The argument would be that the words in any hospital or state-regulated institution apply only to the words the supply of goods.
Well, the comma makes that impossible, doesn't it?
Well, could I?
Or maybe not. Okay, well,
This is not direct or relevant today.
No, well, in that case, let's
there's
leave
certainly
it.
an overlap between the two, would be right. And
Yes, the commas are rather odd, aren't they? But let's leave it. As you say, we don't have to decide it. Right, so you're relying on 1 and 4.
we do. Which cover, between them, perhaps cover, with a bit of overlap, B and C of Article 132 of the Directive.
Forgive me, how do you bring yourself within 1 when you are not a person registered or enrolled?
We bring ourselves in one by saying, if we supply by secondment the services of, let's say, a doctor, someone who falls within 1A, in order, admittedly, to perform medical care, by seconding him to perform services of medical care, we have ourselves, as a matter of VAT law, provided medical care.
Yeah, but the question is, we're looking in VAT terms here. The supplier is the person who is potentially liable for VAT, to charge for that. And the supply is by a person registered. I don't see how you can get yourself within that definition.
Well, again, unfortunately, the brackets here are a little confusing. We would say the phrase by a person registered or enrolled in any of the following governs the words the provision of medical care. It is an adjectival. It doesn't limit.
Well, you can't read that because those words weren't there originally. So the by a person must refer to the supply of services.
You say those words weren't there originally. We don't have.
Note F1 tells you. Note F1.
It doesn't tell us what was there previously.
It tells us that those words were inserted. It doesn't show that anything was deleted.
Well, the insertion of those words can, of course, affect the meaning. It's a truism. It's meant to affect the meaning. You can't say, oh, well, before these words were inserted, this would only have covered a supply by a doctor. After the words are inserted.
It's plainly qualifying what services, not the supplier. Well, there are maybe.
Sorry? Yes, that's what I'm saying. It's qualifying the nature of the service, the nature of the medical. Oh, sorry. I would say it's qualifying my submission is it's qualifying the nature of the medical care. It can't be a medical care by a quack doctor.
What it says, what it previously said was the supply of services by a person registered or enrolled. And so at that stage, it was any services provided by any of those persons. It's obviously been seen fit to make it clear that it's limited to services which consist in the provision of medical care.
This isn't a point that we are relying on. I just wanted to make clear that the answer to your Lordship's point is note 2, which is on page 12 of the hard copy. So, note 2 expressly provides that paragraphs A to B of item 1.
Sorry, where are we? I see.
This is note 2, and the notes to the groups explain how to interpret the groups. So, when we're reading item 1 of group 7, we have to take into account note 2. You have that on page 12 of the hard copy. That says that item 1 to include supplies of services made by a person who is not registered or enrolled in any of the registers where the services are wholly performed or directly supervised by a person who is so registered. So that would include the situation if you have a company that contracts to provide medical services to somebody and the company isn't qualified but the employee is, that would cover it. So there's no dispute between us, and there's never been any dispute between us that a company can come within the scope of the exemption if what the company is doing is providing medical services which are performed by the staff. The question is
This
whether
isn't,
the
you say
company
this isn't that kind of case.
No, the Court of Appeal in
Well, and
May has
and
decided
supervised,
otherwise.
right?
Yes, and supervised. Yes.
Well, there we are. Let's come back to the points you were making. You were taking us, in answer ultimately to my Lord Justice Arnold's point, you were taking us as your starting point to Article 132 and to Schedule 9. Where were you going next?
Well, with respect, my Lord, I don't think we've really bottomed that one out. And
You have bottomed out.
No, because you haven't yet explained in what respect item 1 of Group 7 goes wider than Article 132C, or how such an interpretation can possibly be justified.
well, item 1, read, and I'm going to the learned friend in conjunction with note 2, seems to go further than Article 132C, that it says the provision of medical care in the exercise of the medical and paramedical profession. That would suggest strongly, when Lord Justice Phillips is saying that it only applies to a supply made by somebody who is a member of a medical or paramedical.
Yes, but we know from the Court of Justice that that's wrong. The Court of Justice said the legal form doesn't matter. So, taking up Mr. Baldry's point, the Court of Justice has said it could be a company. So your submission is based on an inappropriately narrow reading of Article 132C.
Well, if I can be wider, the wider provision on which we rely is item 4. Provision of care or medical or surgical treatment.
Right, and
Now, if one looks
what's
at
the difference there that you're relying on?
Well, if one looks at Article 132B,
Well, there may be a distinction as regards 132B, but what about 132(1)C?
well, that item 4 is clearly wider than 132(1)C. That is limited to medical care in the exercise of medical and paramedical professions. Your Lordship was quite right to say the European Court of Justice has given a perhaps generous interpretation of that. There is no such limitation in item 4. It's simply the provision of care or medical or surgical treatment. And there's no reference to in the exercise of medical and paramedical professions.
So what's the distinction? Is it the words medical or surgical treatment? Speaking for myself, I'd have thought those were strictly speaking unnecessary. I'd have thought medical or surgical treatment is care.
It is, but there is care which isn't perhaps medical or...
Yes. But sorry, am I Robbie at cross purposes? C just talks about care.
It also talks about in the exercise of medical and paramedical professions.
Yes.
So it
But
wouldn't...
any medical or surgical treatment would be by people in the medical or paramedical professions. It'd be bizarre if it wasn't. Not operated on by...
But you see, 4 is the provision of 4 in the Schedule 9 is the provision of care.
Yes.
That doesn't mention medical care.
But we're not concerned in the present case with social care, are we?
We're not concerned with
It's
social
all about medical care. So why is any possible threat of the word care of any relevance?
Well, the care doesn't need to be provided in the exercise of any medical, under UK law, it doesn't need to provide in the exercise of any medical or paramedical profession. You could have someone who had no medical qualifications being provided to a hospital to work in that hospital, to assist in the care.
Those aren't the facts of this case, are they?
Well, the facts, unfortunately, we haven't even got any evidence. We're in a very difficult situation. We are, necessarily speaking, hypothetically. And indeed, of course, if the VAT defence is not allowed to be put in, maybe we never will have any evidence on this.
But I'm sorry, your own skeleton argument says the vast majority of the workers were healthcare workers, such as doctors, nurses and carers working in the healthcare sector.
Mm-hmm.
So is your submission that that statement in your skeleton argument is factually wrong?
No, no, Lord. It's not.
Paragraph 2. Last sentence.
Four is probably, well,
Did I understand you to argue earlier that the words "in any hospital or state-regulated institution" did not govern
that's right.
the whole?
Governed only the supply of goods.
Sorry, say that again. I didn't hear.
Governed only the words, the supply of goods. As opposed to.
I find that quite a difficult reading of it. I mean, why would there be a comma after goods? The words that are in parenthesis are in connection with its supply of any goods.
I see the force of your lordship's observations on that. Of course, we haven't, and this is a point which, if the VAT defence were permitted to be put, an Underhill would be able to take.
But you're trying to persuade us that the decision in main pay should not be followed on the basis of this argument. That this argument was not considered. But at the moment, it seems to be. We would seem to be not following a decision on the basis of an argument, which at the moment doesn't seem to have very much force to it, if it exists at all. So we can't just say, well, this will be what's determined at the trial. At the moment, we're trying to decide whether or not it can be permitted to go to trial on the basis that main pay should not be followed. So we do have to understand that there is a point here.
Well, indeed, my lord, the provision of care or medical or surgical treatment. these words, standing by themselves, might have a wider meaning than was contended in main page itself.
But that's the bit I'm struggling with. I mean, I appreciate fully that this is the foundation for your argument, and that's why I think it's an important point to understand it. And I've got the point that you say that those words are wider. But what I'm really struggling with is the basis upon which you say they're wider, and how that is seriously arguable as the correct interpretation.
Well, let me take another example. If I employ a contractor to cut my hedges, he will make a supply to me. I'm going to pay him for it, obviously. He's not going to do it personally. He's going to use employees who will come along and cut the hedges. He may, the arrangement may be slightly different. He may actually second the employees to me for a certain period to work generally in my garden. Now, as a matter of ordinary English, has he provided hedge cutting services? Has he provided gardening services? And the answer is yes. And it's irrelevant that the services are actually performed by his employees. It's irrelevant whether or not he has control over those employees once they've been seconded. So in this case, it's an integral part of Lady Justice Whipple's.
Can I just pause there? You're obviously right about employees. Doesn't seem to me straight away clear that you're obviously right about secondment. Maybe this is well recognised in other areas of VAT law, in which case you can tell me. But if someone is seconded, which you're distinguishing from simply coming to do a particular task, it's not self-evident. A secondment effectively means he's at your disposal to do anything you ask him to do, no doubt within his skills and so forth. He's become part of your workforce for a while. That's what secondment normally means. If that is right, it's not obvious to me that he is, that you are supplying the services of hedge cutting or of gardening. You may simply be supplying the service, the only service you supply is the supply of staff.
Well, my lord, that, your lordship's remark is, of course, very apposite in the example I gave. And again, another example, another illustration of the danger of taking examples off the hoof. But in the context of the way Mercy operated, I think this is, Julie will perhaps remind me that when the employees were seconded, they were seconded to do specific tasks as defined. I think the word assignment may have been used.
Well, I can't believe that means that they were told you must go to such and such an operation and chop off the leg of Mr. Smith.
No, well,
it was you must go and act as a consultant surgeon in the orthopaedic department for a week or a day or whatever. Broadly speaking, that must be how it was, mustn't it?
It certainly wouldn't have been the former. It might well have been the latter. One would have to look at the schedule. We don't have any evidence of a schedule of a particular assignment as to how closely it was defined, but it's more likely to be the latter. But in a case like that, if the employee is a consultant, surgeon say. And he is seconded purely for the purposes of, on the basis that the only services he can be required to perform by the secondee are medical or surgical treatment. Then it's, in my submission, as a matter of plain English, the entity which has seconded him has not only provided its employee, it's actually provided medical and surgical treatment through the employee.
Well, it's you who made the distinction between a secondment situation and supplying someone to perform a particular task. You're obviously right in the former case, sorry, in the particular task case, but it's not self-evident to me you're right in the secondment case.
Well, at this point, do I have to be right, or do I have to have a reasonable argument that I'm right?
Yeah, well, I see that. All I was doing was flagging up that you were saying this is obvious, as if it was the first step in your argument, and I was just pointing out to you it wasn't obvious to me.
My Lord, your Lordship's interjection has been extremely helpful in helping to clarify. We of course didn't get as far as before the judge as to the merits of the arguments. They were simply regarded as not being, well, the matter was precluded by main pay in the Court of Appeal, and only this court, possibly the Supreme Court, could
Yes, I mean,
decide.
at the moment we're still on, although arguably we're crossing the line into the merits of the point, but we're still under the broad heading of what is the point, so we can understand it from the point of view of the main pay argument, i.e. was this decided in main pay, or was this considered in main pay, or are we bound by main pay?
Well, if you start with item 4 of the Value Added Tax Act, Schedule 9, Group 7, sorry. Yes. If you look at that and say the provision of, let's just concentrate on the words medical treatment. And then you ask, in my submission, if one provides someone, if one seconds an employee, on the basis that while seconded, all he can be asked to do is to provide medical treatment. The submission would be that falls within item 4.
And the answer comes back from Lady Justice Whipple, no it isn't, because it's a supply of staff.
And of course that argument I'm yet to address as to why that's, we say, an irrelevant consideration. It's both a supply of staff and a supply of medical treatment.
Yeah, well, she said that they're mutually exclusive.
And of course I haven't yet got to that point in the argument where I...
Yeah, and I appreciate you say that's wrong. Indeed, you go so far as to say it's a manifest error, and we'll get to that in due course. But at this stage, what we're dealing with is the proposition that you can circumvent main pay on the basis of an argument that wasn't run. And at the moment, I'm struggling to see how there's a viable argument that doesn't run up against what was argued and decided in main pay. Because the essence of the argument you're presenting now, I mean, you started from the proposition item 4 goes wider than 1321C, which I'm still dubious about. But when you look at the substance of the argument that you wish to present, it runs straight into what was argued and decided in main pay, doesn't it?
Well, as you say, there are two strings to my bow. There's the main argument that the UK exemptions are wider than the EU ones, and only the EU ones were argued in main pay, or indeed decided. And the second argument that main pay was manifestly wrong, of course, is quite a separate one. But if you look at item 4, of course, you have to be with me, or at least you have to agree that this is an arguable construction of the words, that I can provide medical treatment vicariously, I think is the word used in one authority to which I need to take your lordships. I can provide it by providing the services of a person who is going to provide that treatment. And I can provide it generally by secondment for a period.
But is that the right question? I mean, that's what I'm struggling with, because I can understand the proposition that if you were approaching item 4 as if it were virgin territory, then that might be a tenable construction. But it isn't. And it isn't from two different directions. Firstly, because we've got authorities from the Court of Justice interpreting Article 1321C and giving it, as you rightly accepted earlier, a fairly broad interpretation. And on the other hand, we've got the domestic authorities, which are perhaps a little more focused on item 1, but item 4 was also raised, about how those exemptions are to be interpreted. And so one still comes back to the question, in what way is this really an issue that wasn't considered in Rainbow? And I take your point that at least at the level of there being a potential distinction between the UK exemption and the EU exemption, and that was not debated. But nevertheless, the substance of the point was. That's what I'm warning your help.
Would it be helpful for me to readdress that point after we had gone through main pay?
It might well.
And seen exactly what it does and doesn't slide.
Yes, indeed.
It's a little difficult for me to just go to the centre of it now.
Yeah.
I'm noting that this is something your lordship will need to have addressed.
Well, that seems to be a sensible course. Shall we go straight to main pay, or is there some other step you need to take before?
There is another step, I think. Excuse me. As we've just looked at the ECJ provisions, I just note that there is nothing, and indeed we've looked at the UK provisions too, there is nothing there in either set of provisions which makes a distinction between a supply of staff and a supply of services. And there is nothing which makes any mention of any element of control being relevant.
Forgive me, I slightly struggle with this. The context we're in with the supply of services in this context is services which are paid for.
Yes.
Necessarily, because that payment, the question is whether or not that payment will or will not bear VAT. And we're looking at, therefore, at the supply of services from A to B on the basis that B will pay A. So when we're looking at the nature of the service, it is the service provided by A to B that is in question. Now, does A provide medical or surgical treatment to B in the context of your client supplying its staff to a hospital? And the answer to that question, it seems to me, is plainly not. That supply between A and B is not of medical or surgical treatment, it is of staff.
Well, it may seem very plain to your Lordship that the answer is no, but I would submit that as a matter of plain English, they provide, A provides medical treatment, medical services, and it does so by providing.
It provides staff whom B will then use to supply medical services to C.
Yes, is that incompatible with A providing medical services to B?
Yes, completely.
Well, okay, sorry, there are perhaps two brief answers.
Because it isn't providing medical services, it's providing people who do not provide medical services to B.
There is a decision of the European Court of Justice. It may not entirely meet your Lordship's point, but it is established that, for example, a limited liability company which employs doctors can contract with, say, a hospital to provide the services of those doctors, and that is within the exemption.
Which case is that? It's one of the, I've seen a reference
Is it
to that factual situation, but I can't remember which case it was.
Is it the one started with K? Kugler, which is.
So it's Kugler itself, yeah.
I think that was the actual ratio of Kugler itself, which was relied on unsuccessfully in other respects in main pay.
In main pay. It's not among the cases we've got in our authorities bundle, is it?
No, we're of course rather limited by the practice direction as to the number of authorities we can.
That's not absolute. And I'm not sure that you were limited by the practice direction. Anyway, it's not a criticism, it's just saying we haven't got it, and if it's important to your argument, we better have it.
Yes, my lord. Now, there was a second point. Oh, yes. I'll be taking your... Well, before we go to main pay, we need to look at Reid personnel.
Yes.
And there the analysis presented by the revenue is extremely helpful.
Okay.
Because
Well, we do have Reid.
while it may seem self-evident to the Lord Justice Phillips that there would not be a supply of, and there couldn't be an exempt supply in those circumstances, you will see that the case put forward by the Commissioners of Customs and Excise, which have since been merged into HMRC, was precisely the opposite. So it certainly wasn't an untenable point.
Okay, well, are you going to show us that?
Sorry?
Are you going to show us that?
I am indeed. In fact, Reid is the next thing to do, because I think to understand main pay and to understand in particular the misconceptions in main pay, you have to go back to Reid.
Yes.
And this is perhaps a good point to start getting into the nitty-gritty. It's at the authorities bundle, page divide 8, page 57. And before we look at it, it's helpful to make some points to show what's relevant. It was a decision of Mr. Justice Laws, who was, of course, to go on to become a member of this court. He had particular expertise in VAT law, as when he was at the bar, he'd been standing counsel to the Commissioners of Customs and Excise. Now, the first point to make is there was indeed a distinction made in this case between a supply of staff and a supply of services. However, it was quite different from that which was under consideration in recent value-added tax cases, and in particular, main pay in the Court of Appeal. It was a distinction between a case where the taxpayer, T, supplies in a very non-technical sense workers, yet does so simply by facilitating in some way the formation of a contract of employment between them and third parties. And the archetypal case, indeed this was Reid itself, is that of an employment agency, which, for a fee, merely effects an introduction between two other parties, but does not enter into contracts of employment or of secondment of the services to the employees. Now that distinction, which was very important in Reid, was the distinction, is not the case, was not the case in main pay, and it is not the case in this case.
So you said a distinction between two things.
Oh, I'm
One,
sorry.
merely facilitating employment by third parties,
Whereas,
i.e. an employment agency which affects an introduction. And what's the other side of the
Thank you.
distinction?
the second situation is one which is the present case, where the taxpayer has the right to the services of the workers and itself enters into contracts where it supplies, in a very technical sense, the right to their services by entering into contracts of secondment.
Okay.
That was the case in main pay and is the case here. Now, perhaps somewhat confusing, and we can't blame those involved in Reid. In Reid, the first situation was termed a supply of staff, i.e. where the taxpayer had merely taken steps to help ensure that staff were available. Whereas, paradoxically, the second situation was referred to as a supply of services. So when you seconded an employee, you actually supplied their services. Now, the difficulty is that in that second case, which is main pay, which is mercy, the taxpayer is, of course, supplying staff. For example, it supplies nursing services by supplying nurses. So the distinction in Reid was not as happily phrased as it might have been. This was a different distinction.
Unhappily labelled.
Unhappily labelled, yes. And that has no doubt helped give rise to the confusion in more recent VAT cases. Now, to see the inwardness of Reid, one has to understand why the difference which Reid was looking at was crucial in VAT purposes. It's trite law that the consideration for a supply for VAT purposes determines the value of that supply. So if an employment agency,
Sorry, what determines the value of supply?
the consideration
Yes, I see.
for the service in question. So that if an employment agency, say, charged £50 for finding a worker, it would make a supply, and the value of that supply would be determined by reference to the £50.
Let's call that the commission, because that's the term normally used by.
They might well call it commission. Yes, it is indeed commission, my lord, although the word is sometimes used ambiguously in other contexts. But
I'm willing to use some other phrase, but so we've got to find a phrase, fee if you prefer.
However, let's suppose in a situation like main pay at the present, the taxpayer seconds the services of an employee for £1,050. The value of the supply it makes for VAT purposes is based on the entire £1,050.
Yes, the remaining 1,000 being the bit that goes to the employee.
The employee
to the worker.
Yes.
And it has to go to the worker from main pay, and therefore it has to be paid by the end user. All that's obvious, yes.
Yeah. But it's just that so that even though main pay or mercy may only be left with a gross profit of £50, value-added tax, calculation of value-added tax isn't based on profits. It's based on the consideration.
Yeah. Well, that's because that's how they've chosen to structure their business.
Yes, yes. I'm not commenting that that's,
yes, I see.
That's bad thing. That is undoubtedly VAT law. I'm just trying to explain what the dispute in Reid was all about, because it looks very odd at first.
Sort of looking at it in today's terms, it is entirely backwards, because the arguments are exactly the opposite on each side of what you might expect looking at it from today's perspective. So that's by the by, because surely what matters is the ultimate conclusion. And at the moment, I'm struggling to see why the ultimate conclusion isn't entirely supportive of the reasoning in main pay. So if one goes right to the end, so it's page 65 of the bundle, page 596. And after a lot of hacking through the undergrowth, the final conclusion is straightforward, which is, Mr. Justice Laws says that the tribunal's decision rested on its overall view of the facts, which was that Reid supplied the nurses, who in turn supplied their services to the hospital. That's a conclusion that can't be faulted on Wednesbury grounds, end of. And so he is there accepting the distinction between the supply of staff on the one hand and the supply of medical services on the other hand. And that's the point that Lady Justice Whipple takes from the case. It supports her to that extent, does it not?
My Lord, I'm afraid if one reads the case first, it's exactly the opposite. That she's completely misunderstood what the case does decide and doesn't decide. And I'm afraid we simply have, there is no shortcut to going through it.
Okay.
And it is so important. I can continue now. You're quite right that paradoxically, Reid was contending that it was making taxable supplies, and the Commissioners of Customs and Excise were contending that it was making exempt supplies. But this depended upon the true analysis for VAT purposes. And I will simply note en passant, this of course is not directly the point, that the position of the Commissioners of Customs and Excise in Reid was exactly the position under our value-added tax defence. The position was that Reid was, on a true analysis, seconding the nurses, was making supplies, the value of which was calculated by the entire amount paid by the hospital, but that was an exempt supply. And the third preliminary point is that the case was a seminal case on something which has no relevance to this appeal, namely to what extent contractual documentation is conclusive of the value added tax position. I mention that because that's the only point noted in the head note. So, when your Lordship says I can now start Reid, or would you prefer to adjourn so that I can get in? I'm afraid it will take a little time to go through it.
Well, let's make a start.
So if I can ask you to read the entire head note, please.
Yes.
Now, if I can concentrate on that part of the head note between E and F, this explains how this alleged distinction, well, this distinction between providing staff and providing services is not the one which the Court of Appeal had in mind in Morel. The tribunal allowed the appeal, holding that the contractual documents between Reid and the nurses and between Reid and the health authorities led to the conclusion that Reid had supplied nursing staff, not nursing services. What that means is that Reid had simply introduced a qualified nurse to a client who used her services as and when required, and in addition, Reid provides administrative services. So it is not the case that Reid is employing the nurse and then seconding her services to the hospital. All it is doing is, for a fee, introducing the nurse to the hospital. That's what the VAT tribunal found, and that's what that finding Mr. Justice Laws refused to disturb. But it is not in any way the distinction relied on in main pay between a case where an employee is seconded and you then ask yourself, is this a supply of staff or is this a supply of services? That has no basis in Reid. It's in fact based on a misunderstanding of Reid. If I can take you to page 58, the judgment of Mr. Justice Law. You see, this is a statutory appeal brought by the Commissioners against a decision of the Value Added Tax Tribunal Before the tribunal were appeals by Reid against one, a ruling given by the commissioners to the effect that Reid acted as principal in the supply of temporary nurses to hospitals and a consequential notice of assessment. That was what Reid was complaining about. He said it did not act as principal in supplying the nurses to the hospitals, unlike this case. The commissioners contended before the tribunal that as respects the provision of nurses to the hospitals, Reid was making exempt supplies within what is now the provisions in Schedule 9, Group 7, which we've looked at. If that contention was correct, it was common ground that Reid was not entitled to deduct input tax arising in relation to such supplies from its output tax. The commissioners had, in accordance with their view of the matter expressed in the ruling under appeal, declined to allow such deduction of input tax, and it was on the basis that the notice of assessment were made. So paradoxically, the taxpayer is saying we're making taxable supplies, albeit of a limited value, because we are not employing the nurses, we are not seconding their services. But that does mean we can recover input tax. Whereas the commissioners of Customs and Excise were saying the opposite. They were saying, no, in effect, you are like main pay and mercy. You are making supplies. But, and this is the big difference between main pay and mercy, those supplies are exempt. They fall within the health exemption. And that's why you can't recover input tax.
Very well. Let's adjourn now until 2 o'clock. How are you doing for time?
I hope we can gain time later. I think I do see myself going for a substantial part of the afternoon, my lord, which is why we thought that 2 days would be necessary for this.
Remember, we are still, I appreciate that the way the argument has gone, we have perhaps slipped a way into the merits. We were asking you to consider, first of all, the main pay point only, were we banned. But it may well be that, suppose we were to decide that we weren't banned by main pay, you will in fact have covered nearly all the points you were going to make anyway on that basis. Because they'll all come up under the heading, effectively, of your Morel point.
I think that's right, my lord. Apart from the Crown debt point, which is a discrete.
Well, that comes up at the preliminary assessment, the preliminary issue point, doesn't it?
Is it also on leave to?
I thought it was only relevant to Ground 3.
I'm sorry, it's only on preliminary issue.
Yes, I see.
Thank you, my lord. So but your lordship is basically
Well,
right.
I think we'll wait. Let's see where we are, where we get to the end of your submission, to sort out exactly how we want to handle it from then on. But at the moment, we are concerned only with the point we asked you to deal with first, acknowledging, however, that the Morel point has made that a rather bigger point than it may have looked like.
Indeed, my lord, and I think it is true to say that that will be the vast bulk of my argument, if that's any comfort.
Okay. Well, that's how it seemed to me. Very well. 2 o'clock.
Court rise is able.
I'll take my computer. No,
I'm not taking any of the bundles back. Sorry.
Can you help me? Oh, you need to close it. Close it. It's very helpful to know. You can safely leave our valuables.
I've got all the notes, I don't need anything else.
Lovely, thank you.
Yes, it does. If you're an American, you're right. If you find they have the talent. Yes. Right, we better get rid of what to do.
Yes, sir.